Good afternoon. My name is Philip Munoz. I'm the director of the Tocqueville program and the program in Constitutional Studies. Welcome to our first event of the year, and welcome to what I believe is the first lecture in the Nanovic Hall Forum. We're absolutely thrilled to be here. We're thrilled that you're here today. I just want to start by thanking all the friends of Notre Dame and the leadership of Notre Dame for making this space available to us. Such a beautiful building, and we feel so grateful to really, this is the inaugural event, and we couldn't have a better speaker or topic for it. I direct the Constitutional Studies minor. I know many of the students here are a part of the minor. If you're interested in the minor, if you're an undergraduate, there's information on the tables, or come talk to me afterwards. It's a 5-course sequence housed in political science, but across arts and letters and classes in other colleges. We'd love to have you part of the minor. It's also my privilege to direct the Tocqueville program. Tocqueville program focuses on religion and public life. You can see our event today encompasses both the Constitutional Studies minor and the Tocqueville program. My favorite part of the Tocqueville program is we have our Tocqueville Fellows, a handful of undergraduates who help us plan events, execute events, get to meet our speakers, and several of them are here with us. So could the Fellows, could you stand? Thanks so much. One other person I want to recognize before we go any further, Jen Smith is hiding somewhere in the back. Now you have to understand, this is, as I said, the very first lecture in this building. So she was up late last night setting up the speakers, installing wiring and everything. You did a great job, Jen. One of the things our Tocqueville Fellows do is they introduce our speakers. So I'm going to ask Keenan White to come to the podium. Keenan is a junior here at Notre Dame. Does not live in Keenan Hall. Where do you live? She lives in Baden and is a Constitutional Studies minor and our Tocqueville Fellow. Keenan will introduce our speaker. Afterwards, we'll have time for Q&A, and Keenan will have the microphone. I want to make sure we capture your questions on the mic for the recording. Keenan?
Good afternoon. Like Professor Munoz said, I'm Keenan White, a junior here, and it's my distinct honor to introduce to you our distinguished speaker, internationally recognized expert on bioethics and professor of law, Carter Snead. Professor Snead earned his BA at St. John's College in Annapolis, Maryland, and received his JD magna cum laude from Georgetown University. Before coming to Notre Dame, Professor Snead served on the Bush administration as general counsel to the President's Council on Bioethics. In 2016, he was appointed to the Pontifical Academy for Life, Pope Francis's advisory board on issues of bioethics. Professor Snead is currently director of the Center for Ethics and Culture here at Notre Dame and a mentor to the Soren Fellows, myself included. With Professor Snead's help and recommendation, I've had the opportunity to intern at the Pontifical Academy for Life and at the Beckett Fund for Religious Liberty in DC. Professor Snead is without a doubt an invaluable asset to the University of Notre Dame and the pro-life cause. His lecture is titled, Fighting for Charlie Gard, Ethics, Public Policy, and Pope Francis. Without further ado, I give you Professor Snead.
Thank you very much. Can everybody hear me? You heard me laugh a second ago, and I didn't realize I was mic'd up. Sorry about that. Not laughing at anyone, but with everyone. So today, first of all, it's a real pleasure. Thank you, Phil and Jen, especially, for inviting me to speak today. I'm a huge fan of the Tocqueville program and the Constitutional Studies minor, and I'm a great supporter of the Tocqueville Fellows, and I had the wonderful pleasure of speaking to some of them moments ago. And so I'm happy to kick the year off in this beautiful new space for a very important program and for my friend Phil Munoz, Professor Munoz, who's an amazing mentor and teacher here at the University of Notre Dame. So for those of you, most of you probably have heard about the Charlie Gard case. It was, it attracted international attention. It was a dispute, as I'll elaborate more in a moment, between parents of a severely ill child in London who was staying at the Greater Ormond Street Hospital in London, which incidentally was created and funded by the endowment from the family of the author of the book Peter Pan, just as an interesting little side note. The dispute centered around what the appropriate course of treatment for this child was to be. And the dispute ended up, as some disputes often do, in the United Kingdom courts. In the UK courts, following clear UK law, reached a judgment, and throughout the process, again, a great deal of energy and anxiety and expressions of concern emerged in reaction to this. Both normal folks, but also Pope Francis himself intervened in several different ways in the dispute. And so today, what I'd like to do is to reflect on the Charlie Gard case and its significance for the ethical, legal, and policy dimensions of a variety of serious concerns, including the limits and privileges of parental involvement in these sorts of cases, parental responsibility, the authority of parents for children in medical decision-making, especially in relation to the authority of the state, the meaning of health and the proper ends of medicine, human identity and human flourishing, and then I'm going to focus a little bit on the unique role of Pope Francis in his efforts to advocate for human dignity and the common good generally, and in particular his interventions in this case. So to that end, I will follow this framework. I will begin with a pretty extensive description of the background of the Gard case. I'll talk very briefly about the child's condition. I'll talk about the legal dispute and Pope Francis's intervention, and then we're going to unpack the dispute between the parents and the hospital, the position of the court, and the position of Pope Francis. And we're going to drill down, beginning with their arguments and their positions, we're going to drill down into the fundamental goods that animated their different points of view. What were the competing visions of parental authority at work? What were the competing visions of human identity, human flourishing, what we owe to one another, what the proper ends of medicine are, what health is, what flourishing is, what should be considered beneficial medical interventions, what should be considered futile medical interventions. So we're going to focus on process. We're going to focus on questions of who gets to decide courses of treatment and according to what standard. And then we're going to talk about substance. Again, what visions of health and flourishing animate the various competing conditions, positions. And I'm going also to focus at the end specifically on what Pope Francis did and said and what his vision for human flourishing and neighbor love are as applied to the unique circumstances of the Charlie Gard case. Now, I should point out that the Charlie Gard case was governed by the law of Great Britain, okay? And in the United States, the laws are actually quite different. And they do not have the same procedural mechanisms, and in some ways, they don't even have the same substantive goods at work that animate those legal procedures. So if there's time during the question period and throughout my remarks, I may pause to say very briefly or to make a comparative point very briefly about American law and how it differs from the UK approach. But you should know in advance that what I'm talking about here is UK law. I'll try to be disciplined when I'm making a point about normative positions, that is, principles of justice, principles of morality, and prescriptions about what law and policy should do, because they're not always the same, okay? One might have a very robust idea about what is owed to people who are dying or who are very sick, like how we should make moral choices, choices that are demanded by love and justice in terms of delivering care to someone in need, but we might consider that the actual law and policy should not be identical to our moral judgments. We might decide that we're going to give space for private ordering to make choices and judgments that we would disagree with. And in this case in particular, that issue arises in a dramatic way. So for example, in American law, we cede to parents the authority to make very significant decisions about their children's care. And also we cede that responsibility to individuals who are of sound mind to make judgments about their own care. While we might think that certain kinds of choices for or against different medical interventions, including life-sustaining interventions, are right or wrong, the general legal approach of the American law and policy is to create a lot of space for people to make their own decisions in that context, decisions that we might disagree with. Not just because we care about autonomy and freedom, but also because we might conclude that we don't want to create a legal framework where we have to interrogate people, interrogate parents or caregivers about the choices that they're making in intimate settings in the hospital, life and death decisions, because it would just be too intrusive and it would just really change the character of the relationship between the state and the individual, okay? So we might decide, we might say, and again, I'm not taking a position, I'm just saying one might conclude that the law and policy, the binding law that governs us when we're talking about choosing for other people what interventions to pursue or not, the law might be different from our own personal judgments about what we owe to those people based on moral considerations or even considerations of justice. It's very hard to figure out what the law should be in this area because it's not just about principles, it's also about prudence. Prudence not just about when to defer, but also prudence about what kind of a relationship we want to have between individuals and law enforcement authorities. So, just to be clear, I'll try to be disciplined when I'm making when I'm describing Pope Francis's perspective, or when I'm describing the competing view articulated by the Greater Ormond Street Hospital. I'll try to be clear that those are really normative claims, and that doesn't ultimately settle the question of how we should govern ourselves in this area. They might, but they might not necessarily. Okay? So let's go with what happened here? What happened in this case? Charlie Gard was a newborn, born in August of 2016, and he seemed like a healthy newborn kid, but within a couple of weeks, his parents noticed that he was having certain kinds of physical symptoms that raised alarms in their mind, and they took him to see a general practitioner and ultimately took him to the Greater Ormond Street Hospital, and they determined pretty early on that he had mitochondrial DNA depletion syndrome. It's an extremely rare disorder. It's an autosomal recessive disorder that causes a drop in mitochondrial DNA in affected tissues. Now, the mitochondrial DNA is in our cellular tissue. It's outside of the nucleus. It's in the human organism. It's in the cytoplasm. And the mitochondrial DNA's primary function is to supply energy for the organism's function. Okay, to supply energy by promoting what's called oxidative phosphorylation, conversion of oxygen into the energy molecule ATP. So we don't really need to know the mechanics of how this works, just to know that when your mitochondrial DNA is not functioning properly, it has a dramatic consequence on the activity, your energy levels, and the function of your muscles and your organs. You can't function effectively, and in some cases, if the depletion is serious enough, you cease to function altogether because the energy is not being supplied to the organism. Now, there are variable classes of MDDS depending on the genes involved, depends on the gene mutation involved. The kind that Charlie Gard had is an extremely rare form of MDDS. There are only 16 children in the world, including Charlie Gard, that have been diagnosed with this form of MDDS. So it's unbelievably rare. It's caused by a mutation in a particular gene, the RRM2B gene, causes muscle weakness, but uniquely, among other forms of MDDS, it causes brain damage and kidney damage. And it almost always results in death, ultimately due to the weakening of the intercostal muscles that cause respiratory failure. Okay? it almost always ends in death, and the time it takes it varies, and it varies in part, and it's a little hard to, well, first of all, it's hard because there are only 16 cases, so the N for empirical analysis is quite small, the sample size is quite small, so it's hard to draw any generalizations about it, but, and also it's hard to get a sense of the timing of the progress of the disease, because frequently people will intervene, withdraw life-sustaining measures that will bring about death very quickly. So it's hard to tell with precision duration and causation, those kinds of issues. But for our purposes, all we need to understand is that this was an unbelievably rare form of this very devastating and rare disease, and it uniquely affected Charlie Gard's brain, among other things. And that becomes important in a moment when we're going to talk about a proposed experimental therapy that was used not in these, it had never been experimented on with patients with this particular gene mutation, but had been used with other patients. Now, the experimental treatment that has been used in other contexts of MDDS is called nucleoside-based therapy. It's an oral medication taken daily that replaces compounds that MDDS patients lack. It's been used with some success in patients with a very different form of MDDS called TK2, relating to the gene mutation that's associated with that. But that mutation and that disorder does not involve the brain. Okay, that's why I focus on the fact that Charlie's affliction affected his brain. These patients that experienced some improvement using this experimental therapy, we couldn't draw a lot of predictions about how it would affect Charlie Gard, because it wasn't clear if this medication, if delivered orally, would cross what's called the blood-brain barrier to allow restoration of any sort of the damage that had been done to his brain. So there was a dispute about whether or not an oral drug like this one would cross the blood-brain barrier and thus resolve the brain-related damage that he had suffered as a result. Now, I mentioned that this is oral medication, and that becomes important a little bit when we start analyzing the question of how burdensome would this intervention be? Is it a painful or unpleasant intervention to administer? And because it's oral medication that could be mixed with food, the presumption is that the actual administration of this therapy wouldn't be painful, okay? And the presence of pain matters a lot when we're talking about the different approaches to what end-of-life decision-making should look like from a regulatory perspective. So, I'll talk now about the legal dispute and how it arose between the parents and the child and the hospital, and ultimately resolved by the British courts. So as I said, Charlie was born in August of 2016. They observed problems a few weeks later. On October 11th, 2016, he was admitted to London's Greater Ormond Street Hospital and was placed on a mechanical ventilator. Okay? This is an intervention to help him to breathe. He couldn't breathe on his own or was having difficulty breathing, so it's an intervention involving the insertion of a device to help press air, inflate his lungs, help him to breathe. Mid-November, he was diagnosed with MDDS. Sometimes, by the way, especially with infants or other people who look to be like they're going to be on long-term ventilation, they can perform what's called a tracheostomy, where they make a hole in the neck of the individual and put a more permanent kind of ventilating system in it, as opposed to the ventilation through their nose or into their mouth and down their throat. But the ethics committee at the Greater Ormond Hospital decided they didn't want to perform a tracheostomy. It hasn't been reported what the details of their reflection and consideration were, but I'm just reporting that to you, okay? The child experienced seizures, deafness, and heart and kidney damage. And then on January 13th, the hospital concluded that experimental treatment would not be successful. Now, it's a little hard to get access to all the facts that occurred in this case. You can get the judicial decisions, you can get articles written by reporters about it. I should say that it has been reported that the hospital itself early on thought about this nucleoside-based therapy and even contacted the expert in the US who's pioneered it. The hospital's position is that the expert didn't cooperate with them or didn't respond to them in a timely fashion, and they drew their own conclusions in January that the disease had progressed so far that the experimental therapy wouldn't be worthwhile. So the hospital's position is not that they never considered this therapy or ruled it out completely. Their argument is that they did in fact consider it, and the evidence suggests that they went through their own internal deliberation on this point and decided later on that it was too late to try. Now, there is an intra-physician email. Obviously, the seeds of the dispute originated early on. The parents, understandably, wanted to try to get their child all the help they could possibly get him. They did their own research. They found out about other forms of therapies. They found out about this experimental therapy. And there were, as is often the case in situations like this, there were tensions between the parents and the medical team at the hospital. And the court process revealed an email between physicians at the hospital in which created a great deal of controversy, in which one doctor said to another one, "The parents are a spanner in the works. Recent deterioration with worsening seizures mean the trial is not in his best interests." Now, we're going to talk and try to unpack what's meant by best interests, because in some ways it's certainly decisive under UK law what the best interests of the child are. But we really need to focus on and think about, what does this physician mean when he says best interests? What do the parents mean? What does the court mean? Because that ultimately becomes decisive in the evaluation. So shortly thereafter, the hospital argued for termination of life support for the child. The parents disagreed, that is, the withdrawal of the ventilator, and to give the child palliative care, to give him comfort care, withdraw the ventilator, which would very shortly, almost certainly result in his death. In fact, the argument at court, as we'll see in a moment, is the purpose of withdrawing the ventilator was to hasten and bring about his death, because the hospital concluded that it was in his best interests to end his life, because the life itself was burdensome, and caring for the patient rightly meant eliminating the very life that was a burden to the child. So the parents disagreed. They disagreed, and in fact, they raised more than 1.3 million pounds to fund the expenses of an experimental treatment that they wanted to pursue. They said, "We want to take Charlie to the US to get experimental treatment for these experts that are doing the nucleoside therapy. We think that that's in his best interest. We think it's going to work. We want to do it." The hospital said, "No, we think the right course of treatment is to withdraw his life-sustaining measures to end this life that is characterized by suffering and radical dependence." So February of 2017, the hospital petitioned the UK court, the UK High Court, to intervene under a UK law called the Children's Act of 1989, and they sought an order declaring several things. They wanted the court to declare, with legal force that it is entitled to, that Charlie lacks the capacity to make decisions. That was obvious to everyone. First of all, he was an infant, so by virtue of the fact that he's a baby, he can't make decisions, but especially since he's profoundly disabled as a result of his illness, can't make decisions. So that's very straightforward. They wanted the court to declare that it is lawful and in Charlie Gard's best interest to terminate life-sustaining measures. Okay? They wanted the court to declare that it was lawful and in his best interest to provide only palliative care, and that it was lawful and in his best interest not to undergo experimental therapy, and to act only in a way that maintains Charlie's dignity, which is reducible, I think, ultimately to the second request, which is to say it is in his best interest to terminate life-sustaining measures. Now, here's a procedural point. The decision of the High Court of Justice family decision made it clear in its first written judgment that UK law vests in the court the authority in a situation like this to make the judgment about the child's best interests. Okay? So once the court has taken jurisdiction of the case under the controlling legal authority in the UK, the court now has the absolute authority to make a judgment about what should be done. And the standard that the court looks to is what the child's best interests are. So this is a direct quote. "Overriding control is by law vested in the courts exercising its independent and objective judgment in the child's best interests." So once the court agreed to hear this case, the matter was entirely within the purview of the court. And the parents were only one voice among many that the court could or could not pay attention to, depending on whether or not it was persuaded by their position. The court will consider, but is not decisive. only insofar as the parents' arguments comport with the court's judgment about best interests would that have an effect on the outcome of the case. So this is the first highly controversial element of the case in terms of the international reaction. And this is quite different from US law, which begins with the premise that parents have the authority to, as custodians and guardians of their children, to make judgments on their children's behalf. And it's only in those cases when it is manifestly contrary to the child's best interests that the parents' rights to make decisions for their children will be suspended or abrogated by some external sovereign authority, okay? But in this case, that happens immediately. In the UK, once the court takes jurisdiction of the case, the parents lose their authority. It's effectively, in some ways, termination of parental rights to make medical decisions, which is quite dramatic and quite different from our own system. Now, what about the substantive legal standard? The court has full authority to make this decision, and they're going to make the decision according to the criterion of best interests. In making that decision, this is a quote from the judicial opinion, the first one, the welfare of the child is paramount, and the judge must look at the question from an assumed point of view of the child. So the government, in the form of the court at this point, stands in the shoes of the child and makes a judgment about what that child's best interests are in light of the facts and circumstances. So how does the court approach that question? What are the considerations that go into it? Well, you begin, not surprisingly, with a presumption in favor of a course of action that will prolong life. But the court makes it very clear immediately that that presumption is not irrebuttable, meaning you begin with a presumption. Now, it says a strong presumption. You can judge for yourself how strong the presumption is, because very shortly in the decision, that strong presumption gives way to other considerations that relate to best interest. So we begin with this presumption in favor of sustaining life. However, the court immediately pivots and says, we're going to focus on his quality of life. The quality of life of the child turns out, in this case, to be decisive. And the way the court describes Charlie's life in the decision, it says he can only breathe through a ventilator, and although his parents believe that he has a sleep and wake cycle and can recognize them and react to them when they are close, they realize that he cannot go on as he is, lying in bed, unable to move, fed through a tube, breathing through a machine. Now, we can already see the factors that loom very large in the court's evaluation of what the best interests of Charlie Gard are relevant to his condition. Now, I should point out the parents later on in a subsequent hearing disputed this characterization of their point of view. They disputed that they agreed that his quality of life warranted discontinuation of ventilation support and therefore ending his life. They contested that. And that matters a lot, actually, later on. But I just want to be clear. I want to characterize the parents' position accurately. Later on, they said that that was not their position, even though the court characterized it in this way. So the court turned then to the question of how to assess the possible benefits of the experimental therapy. What exactly might the experimental therapy serve if pursued? Now, there were contested questions about the likelihood of success. The doctor in the US had a different probability of success than the experts at the hospital in London had. So that's a contested question, and I'm not in a position to evaluate the merits of that dispute. But one thing that really is important is when you read the court's decision-making, the court focused on, in terms of evaluating the possible efficacy and thus benefit of the intervention, the court focused on brain function. And it seemed to focus on brain function in a way that was not connected to total organism flourishing. It seemed like its focus on brain function was related to cognition. Okay? The court said, but if Charlie's damaged brain function cannot be improved, then how can he be any better off than he is now, which is in a condition that his parents believe should not be sustained? Once again, the parents later contested that characterization of their perspective, just to be clear. But the fundamental point here is, if we can't fix his brain, if we can't recover the higher brain function that he's lost as a result of this illness, then it's hard to see how this experimental therapy is beneficial. Now, back to the question of quality of life, it became clear in the court's reasoning that quality of life looms very large in its reflection. The court said considerable weight must be attached to the prolongation of life, but it's not irrebuttable, as I said a moment ago. Account has to be taken of the pain and suffering and quality of life which the child will experience if the life is prolonged. So the court's point of view here is clear. If we're taking interventions that will prolong your life, the court will regard those interventions or be skeptical about whether those interventions are in your best interests if the life that it prolongs is diminished by suffering and pain and dependence. But the interest in sustaining life, this is the court again, may be outweighed if the pleasures and the quality of life are sufficiently small and the pain and suffering or other burdens of living are sufficiently great. So the court is focusing here on the life of the patient, the quality of life of the patient, not the nature of the intervention that's being offered. Not the burdensomeness of the intervention, but the burdensomeness of the underlying individual's condition. Now, was Charlie Gard terminally ill? Well, the definition is slippery and difficult to apply. In hospice under American law, and I think this is probably true in UK law, that a diagnosis of terminal illness means that you will die in 6 months or less. Now, most people who enter hospice, it turns out, there was a study by Rand several years ago, actually 70% of them outlive the 6-month diagnosis that they're given. So terminal illness is in some ways not a great or reliable standard for important legal questions. More on that later if we have time. But some experts thought that he was unconscious. Some speculated that he might feel pain but couldn't express it. But there was disagreement on that point. One expert testified that his symptoms suggested that he would die in 6 to 9 months. Okay? So under that definition, if we agree or if we accept for the sake of our conversation that his lifespan was 6 to 9 months, that wouldn't technically fit the definition of terminal illness, certainly under US law and maybe not under UK law. But for our purposes, he was not imminently dying. It wasn't a matter of days. He wasn't imminently dying. Now, the court's conclusion didn't focus on the terminal nature of his diagnosis. They did focus on pain, although the court concluded that it wasn't demonstrated whether or not he suffered pain or not. But what the court said about his quality of life was this: Charlie's current quality of life is not one that should be sustained without hope of improvement. So if this experimental therapy will not restore him to a higher specified level of functioning, then we will not regard it as an efficacious treatment. And giving someone an inefficacious treatment cannot be in their best interests. Given the fact that the court was persuaded that this experimental therapy, even if it improved other functioning of his body, if it didn't reverse his brain damage and restore his brain functioning, the court didn't recognize it as a sufficient good to constitute his best interests. And the way the law works in the United Kingdom is, if the court judges an intervention not to be in his best interest, then the law forbids anyone from following that intervention, okay? So the court, it's not optional. The court doesn't say, we're going to order this nucleoside therapy. If the court says that's not in his best interest, no one can lawfully give him that treatment. So it's a dramatic and important consequence of the court, first of all, taking jurisdiction to the exclusion of any other decision maker, and then secondly, once it decides what those best interests are, nothing can be done that the court regards as not within his best interests. So the court's conclusion here is that what is in his best interests is to discontinue life-sustaining measures, because the life itself didn't enjoy a sufficient quality to warrant continuation. In fact, continuation of his life was positively harmful to him and contrary to his best interests. So the parents appealed that decision and lost. They sought relief in the UK Supreme Court. Permission to appeal was refused by the UK Supreme Court. They sought relief in the European Court of Human Rights, but their application was declared inadmissible, and therefore the case was thrown out. And then finally, the hospital applied for a second hearing to evaluate claims by the parents made regarding new evidence about the possible efficacy of the intervention, of the nucleoside therapy. What new evidence did they present? They presented evidence by the US doctor who claimed the likelihood of success was higher than was assumed by the court. They presented evidence by researchers at the Bambino Gesù Children's Hospital in Rome, which is sometimes referred to as the Pope's Hospital, who agreed to accept transfer because they made the judgment that the likelihood of success was higher than had previously been thought. So the hospital said, let's just go back to court and have the court evaluate the new evidence, and the High Court decided that it would do so. So there was another hearing held this past summer in July of 2017. The US expert flew to the UK. First of all, he testified by remote telecommunications video conference. Then he flew to the UK to confer with the experts, a multidisciplinary team of experts at the hospital and from elsewhere on July 17th. And then we found out, and presumably this follows from their judgment, that his condition was such that the nucleoside therapy would not be efficacious. I presume that's my inference about what the expert concluded, because on the 24th, the parents, Chris Gard and Connie Yates, withdrew their petition for transfer and experimental therapy. They withdrew their petition. The parents very strongly criticized the hospital. They claimed that the hospital's delay throughout these many months led to a deterioration of the child that prevented the experimental therapy from being helpful. And they also criticized them for refusing them to let them take the child home, to pass away at home, or even in private care. The final declaration that the court entered declared that the child would remain in the treatment of the hospital, transferred to hospice per the hospital's instructions, and that ventilation would be removed, which they did, and Charlie Gard died on July 28th as a result. So let's unpack the court's decision and evaluate what norms were animating its perspective and its definition of best interests and the like. So the procedural dimension here, it's clear that the court, under the UK law, the court has pride of place in determining the child's best interests from the child's perspective, not the parents. Best interests, as we've already discussed, includes a presumption that continued life is important, but as we saw, that presumption can be easily overridden in the name of quality of life. And quality of life of the patient defines the contours of medical benefit versus medical futility. If the medical intervention cannot restore a particular predetermined quality of life, then it will be deemed futile, even if it achieves its proximate goal. So what we're talking about in this case is a ventilator, right? The ventilator achieved its proximate goal of sustaining the child's life by aiding his breathing, right? But the court didn't recognize that. And by the way, let's focus, it's important for us to focus on the experimental therapy as a medical intervention that was proposed, as well as the ventilation, which is a medical intervention that was deemed, both of which were deemed problematic and futile and were ordered to be withdrawn by the hospital, and that position was accepted by the court. So if the nucleoside therapy doesn't restore you to a preferred level of cognitive functioning, or brain functioning, then it's deemed futile, even if it helps to ameliorate other symptoms, okay? If the ventilator preserves a life that is characterized by suffering and dependence, it is not medically efficacious under this approach, where quality of life governs what should and shouldn't happen and therefore should be terminated. As I said, the court focused on brain function in a manner that seemed to privilege cognition among other considerations. The inability to restore brain function seemed decisive in evaluating efficacy versus futility. And the court also focused on the radical dependence of the child, lying in bed, can't move, can't do anything, and his disability as factors weighing in favor of terminating treatment. So again, it's important to note in evaluating what the court was doing here is it evaluated the promise of the proposed therapies and the life-sustaining measures according to an idealized quality of life threshold that if they were persuaded, as they were, that Charlie's life would still be below that threshold with the medical interventions, then the medical interventions were deemed futile, in fact, contrary to his best interests, and must be terminated under pain of law. So why did Pope Francis intervene? Why did he intervene in this case to try to add his own extraordinarily powerful prophetic voice to this conversation about what was owed to this child and what was owed to the child's parents? Well, Pope Francis intervened. Let's look at what he said. First of all, he issued a statement that said, "The Holy Father follows with affection and commotion the situation of Charlie Gard and expresses his own closeness to his parents. He prays for them, wishing that their desire to accompany and care for their own child to the end will be respected." So he weighed in on the side of the parents in the dispute. He weighed in on the side of the parents that they should be empowered to make decisions for their child, and that the substance of those decisions should reflect the goods that the parents seem to be operating from. And that's illustrated in this next comment by Pope Francis, that to defend human life above all when it is wounded by illness is a duty of love that God entrusts to us all. So he offered, it was Pope Francis that encouraged the Bambino Gesù Hospital to make transfer available for the child to come to Rome for treatment, for the experimental therapy. He even considered offering the child a Vatican passport to make the child a citizen of the Vatican so that he would be able to be transferred from the UK to Rome for treatment. None of that was effective because the force of British law is that once the court decides that a particular intervention is not in the child's best interest, it is unlawful for anyone to intervene to act in a way that's contrary to those best interests. Now, we all know that Pope Francis has regularly spoken out in favor of radical hospitality and care for and solidarity with those who are suffering and those on the peripheries, those who are poor, those who are disabled, those who are hated, those who are looked down upon. And he has strongly criticized what he has described as a throwaway culture in which the weak are cast aside and neglected across every context, not just the context of bioethics, but the context of economics and immigration policy and the like. He's embraced a vision of human identity and human flourishing that regards all persons as equal in dignity and respect, regardless of their condition, their circumstances, and for sure, the judgment of others. Accordingly, he holds that the good of medical care should be applied to a patient as we find her, caring for her needs as they are now. We give the patient, we encounter the patient, we determine what will help the patient in his or her current condition, what will comfort her, what will ameliorate her conditions, what will improve some aspect of her well-being to the extent that we can, given the facts and circumstances of that child, that patient, as he or she presents to us now. Not according to an idealized standard of flourishing or quality of life, rooted in cognition and independence, which is the separate position, the competing position, that animated the British court's assessment of the case as well as the hospital's assessment. Their position was, we have a standard of quality of life, and if your life falls below that quality, that standard, then the most humane and beneficial thing that we can do is to take steps to end that life through the discontinuation, or at least to stop doing the things that will prolong that life. But the purpose, let's just be clear though, the purpose of withdrawing his ventilator in this case was not to remove an unduly burdensome intervention because it was painful or even expensive or whatever. It was to withdraw care so that the child can die with dignity, because that is what is in the child's best interest, because his life itself, characterized by suffering and dependence, was a burden that the humane response would be to ameliorate. So let's dig into Pope Francis's framework a little bit. What is this alternative framework? And I want to be clear that I'm not prescribing right now an operationalized set of regulations that should be embraced by any jurisdiction. This is not, what I'm talking about and what Pope Francis is talking about is how to think about how to care rightly for people who are sick and who are dying and who are disabled, okay? What's the framework to think about what we owe to these folks? And then once we sort that out, we can ask the question of how should the law respond to that? Is it possible to translate those goods in love and justice that we owe to others into sustainable and administrable legal regulations? We might ultimately conclude that there's no way to lift the one and operationalize it in the law. We might not be able to do that for a whole variety of prudential considerations. But let's talk first about what those norms are that animated Pope Francis and led him and prompted him to intervene in this case. So the question is, how do we think about our obligations to care for the sick and disabled in a way that resists a throwaway culture? How do we resist a culture that empowers the strong to withhold or withdraw care from the weak because of the judgment of the former, the strong, that the latter's lives, the weak's lives, are no longer worth living? How do we do that? How do we avoid the precarious situation where able-bodied, able-minded, powerful people are restrained from deciding who lives and who dies based on their assessment of whether or not a particular quality of life merits continuation? There are interesting studies, by the way, that show that we do a very bad job of understanding the value of life in diminished states, including the doctors that care for children with disabilities or people with disabilities. If you poll them, social science evidence suggests that it's really hard to stand in the shoes of another person who's disabled and make judgments about what sort of life is worth living and what isn't based on an able-bodied perspective, okay? And the way these studies work is they ask the patients, they ask the doctors about their appraisal of the relevant quality of life, and usually the people, overwhelmingly the people who are disabled, value their lives a lot more than the doctors who care for them, even though the doctors are not bad people by any means. They've given their lives and their work and their energy to care for these patients. But you ask them, where's the line, where's the quality of life line below which life is no longer worth living? And the perspectives are dramatically divergent. The people who are living those lives value their lives a lot more than the people who appraise those lives who are not in that position. And that should give us a lot of pause about a legal rule that empowers able-bodied, able-minded, strong people to make judgments about quality of life that have consequences, like in this case here. So, if we want to think about Pope Francis's understanding of care and accompaniment, what does that mean in terms of procedural goods, procedural norms? Well, Pope Francis's position is that parents should make decisions on behalf of their children's care, and such judgments must only be overridden when they are manifestly contrary to the child's best interests. Okay? The default position is the parent who loves the child and cares for the child is best situated to make decisions in the child's best interests. Okay? As opposed to the parent's voice being one among many to be arbitrated by a separate body, whether it be a hospital or a court. Now, again, this is just sort of feeling around for a procedural principle. Obviously, applying this to concrete cases or even trying to take this idea and translate it into legal principles is a complicated question, and I'm not proposing to do that right now. How about the substance of the matter? What is the meaning of care and accompaniment that seems to animate Pope Francis's involvement in this case, that is rooted in long-standing Catholic social teaching about medicine and how to approach these difficult situations where you have to evaluate situations for people? And let me just be clear, another premise of this conversation is we're talking about deciding for others. We're not talking about deciding for people who are able-minded, who can make deliberative decisions on their own. What we're talking about is a case like the Charlie Gard case, where you're making a decision for someone who's incompetent and incapacitated and trying to figure out how rightly to care for this person in this uniquely vulnerable and dependent state. Okay, I just want to be clear about that. So care, following traditional Catholic social teaching, care is obligatory and intervention is obligatory for an incapacitated child when such an intervention is beneficial to her health and comfort in light of her present needs, rather than according to an idealized standard. Care is optional when the intervention in question is futile, and I would argue that what that means here is not whether it can restore someone to an idealized level of functioning, but rather whether or not it fails to achieve its proximate goal. So in this case, I would argue that the ventilator, the life support in this case, was not futile because it was succeeding in keeping the child, prolonging the child's life. Now, I would have to know more about how nucleoside therapy works to venture an informed proposal about whether or not that would be futile in this case. I would have to know about what it would do, what the likelihood of success it would be in terms of restoring functioning in other systems. But I'll tell you, my position is not, and I think it's clear that Pope Francis' position is not, that futility, in evaluating the futility of an intervention, is whether or not it restores cognition, is not whether it will return a person whose cognition is diminished into an improved capacity for high-level thought and cognition. That's not, in my judgment, an understanding of futility of a life-sustaining intervention. Secondly, an intervention is optional if it's unduly burdensome. And this relates to, with respect to the nucleoside therapy, whether or not it's painful. If an intervention is unduly painful to the individual or otherwise burdensome, meaning, and burden can come in a whole wide variety of forms. Burden can come in the form of expense. It could come in the form of pain. It could come in the form of psychic trauma associated with the intervention. There are all kinds of reasons why an intervention could be deemed unduly burdensome and thus optional in a case like this. So Pope Francis's position and the position of the Catholic Church is not a vitalistic position. It's not the position that all life should be sustained no matter what by any means necessary. What it is certain means of medical interventions are obligatory when they're beneficial, and they are optional when the intervention is either futile, doesn't achieve its proximate goal, or unduly burdensome, which leaves room for a wide range of discretion in determining whether to pursue or not pursue a particular medical treatment. And incidentally, I would add to this that whether an intervention is futile or unduly burdensome has to be informed by the facts, of course. But at the end of the day, it's the role of the caregiver to make that final, the parent to make that final decision in a situation like this. And it's contrary to the proper ends of medicine and the demands of love and justice to act or withhold action for the purpose of ending the child's life that is perceived as burdensome. So this approach here is squarely contrary to the Greater Ormond Street Hospital's approach and the approach of the UK. This approach rejects the notion that some lives aren't worth living, and therefore we should terminate life-sustaining measures for the sake of ending that life. A human being is never a burden, right? A human being's life is never a burden. What we focus on in evaluating burdensomeness and futility is the proposed intervention, not the underlying condition. So that is, in some ways, a recapitulation of long-standing Catholic social teaching on the question of what is sometimes called ordinary and extraordinary means of care, which are actually, those are more conclusory terms. They don't really help you with the analysis. Really, I think the appropriate way to think about it is through the lens of futility and burdensomeness and determine whether it's optional or obligatory. Okay, applied to Charlie Gard's case, think about the experimental therapy, life-sustaining measures, and the decisions for parents. The questions that parents would have to answer is whether or not they would fail to achieve their approximate goal to aid the patient that Charlie is now. Are they unduly burdensome, informed by the truth of the matter as explained by thoughtful practitioners of medicine and science? If the answer to both questions is no, then the intervention is obligatory. If the answer is yes, then the parents can choose to pursue or not. And let me just be clear again, this is a normative framework. We might conclude, if we are in a legislature in the US, that we can't turn this into a legal standard, that the best we can do is to allow parents to make decisions that are manifestly in the best interest of the child, and to disallow intentional actions that will, active killing like euthanasia, and then give space for private ordering when it comes to withdrawing life-sustaining measures or not. We might draw that conclusion. That, by the way, is generally speaking what the US government has done and what the various states have done. This is generally a state law question. So, I've gone on for too long. That's Charlie Gard. I've gone on for too long. I'm happy, with Phil's guidance, I don't know how much time we have left, to have conversation and take questions. Phil, do we have time?
That's fantastic.
Thank you.
We have just a few minutes for questions. We have a tradition here at the program, which is we always invite our undergraduate students to ask the first question. Make sure Keenan reaches you before you ask the question. So, any undergraduate students with questions?
There's one.
And tell us, stand up so we can hear you, and tell us your name and where you are here.
Hi, my name is Nick Abushadid. I'm a freshman this year, and I'm living in Dillon Hall. So you talked about the importance of giving parents kind of the decision of their children's health or what care they receive. Can you explain how that doesn't allow for them to choose, say, abortion, or like how that's different?
Yeah, no, that's a great question. And so I tried to make the distinction clear that what I'm talking about in this case is the decision-making for a patient who needs medical care who can't decide for him or herself, okay? if you were to ask me about, the outer limit, and in some ways, in this way, I sort of am in agreement with the UK court, the outer limits of a parental authority is the best interest of the child. An action that is manifestly contrary to the best interest of the child cannot be pursued morally or in justice or in love. And I would say that, you know, we have the task as citizens and legislators to figure out how to draw those lines, you know, with respect to regulation and law. So I would say that, for example, I mean, we already have good examples in family law where we don't permit abusive decisions for children. And we have interesting examples in the medical context where you have parents who are, let's say, Jehovah's Witnesses, and the child needs a blood transfusion. We have instances where the law overrides the parent's judgment that the child shouldn't get a blood transfusion based on religious premises, and they do that anyway because it's a matter of life and death, and the consensus is that that's an issue that would not allow the child. You could come up with even more dramatic examples, right? Where you say the parents think that a child would be best served by having a healthy limb amputated or something like that to ameliorate a body dysphoria that the child has. That wouldn't be permitted because it's so manifestly clear. Now, drawing the lines of best interest is hard, as we've seen here. What Pope Francis thinks is in a child's best interest are different from what the UK court thought was in the child's best interest. So the best we can do is define best interest. From my perspective, to venture a suggestion here is parents don't have total autonomy to make decisions for their children that will hurt the children. I mean, if a parent can't decide, for example, to commit euthanasia in the United States, or in the UK for that matter, if Charlie Gard's parents said, this child, we need to give him a lethal injection to terminate his life because his life's no longer worth living, that would have been illegal. You know, the court itself couldn't have ordered that relief because it's illegal. Because in the UK and in the US, euthanasia, direct killing in that way, is as a matter of consensus out of bounds. So I would say on the question of, so I'm not arguing either in morality or justice, or for sure not in a legal setting, for absolute unchecked authority by parents, right? But the UK system is the opposite of that. The UK system is absolute unchecked authority by the government just merely by filing a claim, as the Greater Ormond Street Hospital did. Is that responsive to your question? Yeah.
Another undergraduate question? Okay. Older undergraduates. This one right here. Again, stand up and tell us who you are.
I'm Mark Sellner. I'm a parent of a rising senior. Is this more a socialized medicine or a legal issue, and how close are we to having this problem in the U.S.?
It's a great question. Now, some people made the case, I think Vice President Pence made the case, that what we're seeing here is the consequence of socialized medicine. I don't think that's a fair appraisal of what happened in this case. The family raised 1.3 million pounds to pay for this experimental treatment. Money was not an issue. The court made it clear that money and scarcity were not driving this case. I think that this case, it's hard for me to imagine a case in the United States where parents had the money and the will to pursue an experimental therapy for their child and the government stopped them from doing it, if it were a legitimate therapy, not some kind of crazy crank science thing. So I think when I study this case and think about it, it does not strike me as a cautionary tale about socialized medicine.
Hi, I'm Tom Gill. I'm with St. Joseph County Right to Life here locally. And you mentioned the term dignity a couple of times. Yeah. Do the courts in either the U.S. or the U.K. recognize that? Is there a legal definition for dignity, or do they measure it in a certain way?
So I can't speak to the UK law. They invoked it in this case as a rhetorical argument. In the United States, human dignity does not have a juridical meaning or status in the way that due process does, or reasonableness does under the Fourth Amendment, or privacy does as interpreted by the relevant Supreme Court precedent. There are normative goods that have those names. Dignity has been used, in my evaluation, as a second-order rhetorical principle to shore up support for those other ones. So, for example, in Eighth Amendment jurisprudence involving cruel and unusual punishment, there have been cases involving demeaning and degrading and painful treatment and neglect by prisoners. And in those cases in which they have which the court has overturned that state action or has chastised that or allowed for civil rights claims to be heard in that context. They've invoked dignity as a kind of good that is violated in that case, but that's not the good that the Eighth Amendment prevents against. The Eighth Amendment prevents cruel and unusual punishment. The word dignity is a sort of secondary consideration. In fact, the first use of the word dignity was in the Federalist Papers, and it was used to refer to institutions themselves, not individuals. So the notion of personal dignity is something that emerged much later on and is most prominently associated with the German basic law in response to, and intergovernmental documents like the Universal Declaration on Human Rights, associated with a reaction to the atrocities of the Holocaust and as a kind of principle to rely. But in international law and in the constitutions of, I think, 45 constitutions of non-U.S. governments include dignity specifically. There are 3 or 4 U.S. jurisdictions that use dignity in their state constitutions. Montana has a dignity clause in its state constitution. And as you can imagine, the meaning of dignity is quite contested. The dignity clause in the Montana Constitution has been invoked to promote certain kinds of practices that would be regarded as anathema to dignity by other people, right? So we hear it a lot in the euthanasia context. Death with dignity doesn't have legal meaning. It has a kind of dignity is used in the context of practices, state practices that shock the conscience under substantive due process jurisprudence. So the short answer to your question is dignity doesn't have concrete operationalized meaning in American law, but it is invoked rhetorically to shore up other principles that do have operational meaning.
My name's Marissa, and I'm an LLM student. So my question is, how much do you think this case was actually a failure of the doctors to come to some sort of agreement on the patient plan with the parents in order to keep it out of the courts? And then once it kind of got into the court system, it was sort of doomed from the start.
Yeah, that's a really good question. And in most cases, so in the world of law and bioethics, the cases that you read about that involve disputes over end-of-life decision-making, the Shivo case, other cases, are the exception to the rule. Most every case in real practice of end-of-life decision-making is done informally, collaboratively, sometimes pursuant to medical power of attorney or an advance directive or something like that. Most of these cases don't end up in court. They end up in court when there's a radical disagreement about what's owed to this patient. And it's possible, although I'm not 100% sure, that in this case, if the hospital had been more attentive to the parents and maybe more humane to the parents, and we saw that one email where the doctors were extremely dismissive in a coarse way of the parents' concerns, that maybe this could have been resolved in some other way. But if the disagreement really was, on the one side, the best thing for Charlie Gard is to withdraw life-sustaining measures so that he can die versus continuing to try to care for the child that he is now in this diminished state, then it's hard to see how you would come to a resolution on that. But I'm sure that as in all human interactions, being kind to one another would have been helpful.
One last one. Oh, I see 2 hands. We'll do two last questions.
Yes, Daniel Van Nostrand, law student. So there were seemingly 2 debates going on about the Charlie Gard case, one of which was the different views of human dignity and what was good for a patient, and the other being parental rights versus state rights. Mm-hmm. And your talk predominantly focused on the differing views that Pope Francis and the UK courts had. Was there any parental rights issue that influenced Pope Francis' decision, or was that not really something he was considering?
Well, Pope Francis' early interventions focused on the parents, and he said, I accompany the parents in their effort to care for their child and to do what's necessary for the child. He gave a substantive claim, so that's a procedural point. I'm with the parents, okay? I don't know, because if you imagine a hypothetical in which the situation was reversed and the hospital wanted to keep the child alive and the parents wanted to discontinue medical care, would Pope Francis have intervened on their behalf? My suspicion is no. My suspicion is that he wouldn't have done so. He might not have got involved at all out of respect for the profound complexities and the serious gravity of overriding parental decision-making on behalf of their children, right? That could, I mean, I'm really speculating now. But But he gave a substantive principle when he talked about caring for the disabled, caring for those who are wounded by disability, all the way to the end. And so I think there's both, I think Pope Francis, I think it was a sort of alignment of the procedural good of parental choice and authority over their children, and the substantive good of caring for the disabled and the wounded as they present themselves to you and ministering to what their needs are now and in this condition, as opposed to making medical choices based on an idealized standard.
Hi. I had two questions. One was a clarifying question, and then one was a substantive question. So out of the 16 cases that you mentioned earlier of the people that have this disorder, how many of them, or if any, did they make it out of infancy?
The statistics that I've seen, let me just preface this by saying I have only explored the literature in a very superficial way, right? So I'm by no means an expert on this. My understanding is that they take the life expectancy is I recall reading something that suggested that these children can make it beyond infancy, but I probably the best answer is I don't know the answer to your question.
Okay. And then my second question was in regards to the parents always having the best interest for the child. A thought of that passed my mind was that though you assume that they would have the best interest of the child, they probably have the best interest for themselves, which would be to keep the child around regardless, because it's their child, they don't want them to die. But in some cases, you have to have an outside party to see is this actually the best interest for the child, which comes with the doctor's judgments come to call. And if we're not trusting doctors who go to school their whole life to make these decisions, who have seen situations such as these unfold in front of them, to make those decisions or to at least have a say in this, and we're just leaving it up to the parents who are biased, and true, I mean, if we're not trusting doctors to make these decisions, like what are we trusting them to do, I guess? Yeah,
and that's a good and sharply framed comment. I would say that my immediate reaction is I share your kind of bias for expertise. Like I like experts. I like relying on experts. I like relying on people who have worked very hard to learn a whole lot about various things. I'm nervous about the idea that these matters are reducible simply to technocratic considerations. I don't know that the doctors can tell the family if they, and again, there was a dispute here, but the doctors could tell, if there was not a dispute, the doctors and experts can tell the family what the consequences of an intervention are likely to be, how it's going to work, what the condition is, what the child's experiencing, and so on. I'm not sure that I would want to privilege expert judgment on the question of the notion of futility and burdensomeness in its full normative form. That is, there's also a kind of bias that emerges, almost reductive materialist bias that emerges in certain kinds of contexts where, where certain doctors, and how many cases have we seen where doctors have said, there's no way this is going to work, and the parents are like, I'm not giving up on the kid, and then you have the heroic outcome where it turns out the kid did fine. Other situations where that doesn't work out. The difficulty is, and I think this is just sort of to restate your question as a declaration, is the difficulty we have here is to balance respect for expertise and objectivity on the one hand versus subjectivity and perhaps over-optimism on the other hand. I don't know. I'm not as sanguine, I guess, as you are about the neutrality and wisdom of experts in a situation as complicated as this. And I think the American system does a pretty good job of balancing those considerations. So in the United States, in a situation like this, what would happen is if the hospital is like, this isn't working and we're not willing to participate in it, then they arrange for a transfer for the kid to some other hospital, and they find somebody who's willing to accept them, right? And the parents get to make that judgment. And the only time we suspend the parents' rights is when they take a decision that is manifestly, squarely, obviously contrary to the child's best interests. And I think that strikes the right balance between parental authority and appropriate respect for expertise, and our ex-ante judgments about who's biased and who's neutral. So I think the American approach is actually pretty good. And namely, we have the strong presumption that parents can make these decisions on behalf of their children. They're closest to the kids. They love the kids. And if the doctors think this is crazy, or even futile, the doctors say, all right, we're not going to do this. We're going to facilitate transfer to some other facility if there's a facility that's willing to take the kid. In this case, there was. You had the Bambino Jesu that was willing to take them on. Hard for me to see the harm that it would have done to allow the child to be transferred either to New York or to Rome if that's what the parents really wanted and thought was in the child's best interest.